Muted.
Today's webinar will begin now. Good afternoon, and welcome to ASA's safety webinar on OSHA's new e-record keeping and anti-retaliation rule. I'm Michael Place, Training Director for Dakota Supply Group and the Chairman of ASA's Safety Committee. Each month, the Safety Committee publishes articles and toolbox talks on a variety of safety-based subjects. These can be viewed and downloaded from the ASA website at www.asa.net. Also available on the ASA site are recordings and downloads of previous webinars. All of these items are available free to the public. To view these resources, look for the Safety Resources link on the ASA homepage, which is located at www.asa.net. If you have any problems, contact Dan Hilton at the ASA for assistance. At this time, I'd like to draw your attention to ASA's supplier partners shown on the screen. They are very important to the work we do, and the Safety Committee would like to thank them for their industry leadership and for supporting our committee and these webinars. This webinar is being recorded for later viewing. Everyone that registered for the webinar will receive an email notifying them when and where the replay of the webinar is available. Attendees will also receive an emailed link to its location. All attendees are in mute mode. To submit a question during the presentation, you can enter it in the chat window. Before you send it, be sure your setting is set to send the question to our organizers and the panelists so we can see the question. Questions will be answered at the end of the presentation as time allows. Also, an FAQ document with all questions and answers will be posted on the ASA site along with the replay of the webinar. Other related documents will be posted in that location as well. I would now like to turn our attention toward today's event. Today's webinar is presented by Conn, Maciel, Carey Law Firm. CMC is a law firm focused on labor and employment, workplace safety, and litigation. They provide strategic guidance to a variety of individuals and institutions, ranging from employment counseling to managing government regulatory investigations. They are an expert on the challenges facing workplaces throughout the country. Today's presentation title is OSHA's new e-record keeping and anti-retaliation rule. Our presenters for this webinar are Eric Conn and Kate McMahon. Eric is chairperson for the OSHA Workplace Safety Practice Group at Conn, Maciel, Carey Law Firm, where he focuses his practice on all aspects of occupational safety and health law. Kate is a partner in the OSHA Workplace Safety Practice Group at Conn, Maciel, Carey. The focus of her practice is in the areas of OSHA and environmental law. A full bio of the presenters will be posted with the webinar documents on the ASA website. I'd now like to turn the presentation over to Eric and Kate.
Thank you very much for the introduction, and thank you to ASA for inviting Kate and me to join you. The faceless voices that you'll hear for the next hour or so, this is Eric Conn, and I'm joined by my partner, Kate McMahon. And we're going to occupy a very valuable hour of your time today talking about a rule that may well end up in the garbage can after inauguration in January. And we'll talk a little bit about what is likely to happen in terms of the different elements of the rule, what's likely to go into effect, what's likely to be changed in a meaningful way, or what's likely to disappear altogether. But that is one of the things that this is perhaps the least predictable transition of administrations that I can ever recall. I mean, I think we're seeing the nature of the appointees and the campaign promises, which gives us an expectation of what's going to happen with this rule and other rules that were promulgated towards the end of the Obama administration. But for right now, these rules are in effect and will require some action over the course of the next several months, pending some change in direction from the administration. So what exactly are we going to be talking about today? It's the electronic record-keeping rule and the various elements of that. We'll talk a little bit about the injury data e-submission requirements, what data is required, what types of employers are covered by the rule, and what it is that you'll have to do, and what the agency may do with the data that is submitted under this rule. Then we'll talk about the anti-retaliation elements of the rule, and you've probably heard or read a fair amount about the idea that this rule, although it seems to have nothing to do with the actual substance of the rule, will cause a limitation or prohibition against certain types of post-injury drug testing, safety incentive programs, and the nature in which we compensate or bonus employees and managers at our companies. And then as a final topic, we'll talk a little bit about the landscape of the rule now, what's in effect, what's coming into effect, and then what might be the future of the rule under a Trump administration. So I'm going to hand it over first to my partner, Kate McMahon, to talk about the electronic data submission elements of the rule.
Thanks, everyone, and it's good to be with you all. Let me spend just a few minutes talking about this first portion of the rule. As Eric described, there are essentially two different parts to this rule. The first is the electronic record-keeping rule, or portion of the rule, and the second is the anti-retaliation portion of the rule. So let's talk first about the e-record-keeping part of the rule. This is a brand new rule, just promulgated this past year, May of 2016. The first effective date, the date by which you all will have to do something, is July, this coming July 2017. Let me tell you which employers are affected and how you're affected. There are essentially two major provisions to this portion of the rule. The first requires all employers that have establishments, and I'll talk about what an establishment is, with 250 or more employees. Those establishments will be required to submit annually their OSHA 300 logs, the 301 incident reports, and the 300A annual summaries that are generated at those facilities or at corporate headquarters on an annual basis. In addition to that, the other major provision to this e-record keeping part of the rule requires establishments, again, we'll talk about what those are in a minute, with 20 or more employees who work in, quote, high hazard industries that are in fact identified explicitly in the rule by NAICS code. Those establishments will be required to submit annually just the 300A annual summary. So you won't have to submit the 300 logs or the incident reports, but you will have to submit the 300A summary. So let's first talk about the 20 or more employees, because that, of course, will affect almost everyone of any size whatsoever. Industries that have been identified by OSHA as high hazard are listed on the screen in front of you. If you're looking at it in color, we've identified in red those NAICS code industry sectors that you all fall into, and those include manufacturing, wholesale trade, warehousing and storage, and some of you fall under building material and supplies dealers. So those categories of industries or industry sectors are considered high hazard industries. Therefore, if you have 20 or more employees, you fall under this rule. Of course, if you have 250 or more employees at an establishment, then you're in the rule regardless of what industry you're in. Okay, how do you do the employee count to make the determination as to whether you have 20 or 250? You have to consider the total number of employees at peak employment during the year. So what that means is if there's seasonal work, you increase your number of workers in order to deal with seasonal orders. If you're busier in the summer than in the winter, whatever, you look at the highest or peak employment period and you include all workers, including even part-time workers. All right? So it's the broadest possible interpretation of employee. Second, the way you look at establishments, and this tends to narrow the way you either fall in or out of this rule, you look at a single physical location. So an establishment is a single physical location where business is conducted or where services or industrial operations are performed. All right? So you don't total the whole company up. You look by location. So that means, of course, you have to do a location-by-location assessment to determine whether you meet the threshold numbers. Employee count by corporate entity at each particular location. Again, don't add everyone together. Separate it out by physical location. For the 20 to 249 level, you ask yourself, are you in one of these high hazard industries that we had on the slide a couple slides ago? And those, of course, are based, as I said, on NAICS codes.
This is the idea here, is that the NAICS code for your warehouse operation may well be different than the NAICS code for your headquarters or administrative offices. So you may, and you have some control over which NAICS code applies to your business. And this rule may be a reason to evaluate how we designate the NAICS code for different operations, but it may differ across different locations within your network of establishments. And so the idea here is that if one location within your business is swept into the rule because it is covered by a NAICS code covered by the rule, that doesn't mean that all establishments are. You do an establishment by establishment analysis of the number of employees and the applicable NAICS code for that location.
And we've done that for several of our clients to make determinations as carefully as we can to obviously exclude those facilities that don't have to fall within this rule. All right, so let's talk a little bit about the impact of this rule. This one sort of slipped in at the tail end of this administration. There were a lot of initial comments during the rulemaking process that were critical of the determination, but OSHA got it. OSHA got this rule finalized, notwithstanding the critical comment from industry. And what it does is it essentially quadruples, as best we can tell, the number, as best OSHA has estimated, the number of employers who are going to be required to submit injury data to the Department of Labor. As you all know, up until this rule goes into effect or has been finalized, the only people who are actually submitting log data to the Department of Labor are those entities that receive questionnaires from the Bureau of Labor Statistics, BLS, and that's a smattering of employers across industry nationwide. This is going to obviously, raise the number of employers who are reporting by a huge magnitude. The estimates show for those employers who have establishments of 250 or more employees, we're going to have an increase up to about 129,000 sites on an annual basis. For those with 20 or more in high hazard industries, we're expecting to see 160 to 440,000 sites. So OSHA is going to receive over 1 million, we've got up there 1,325,000 cases presumably to review and make an analysis of.
And that's the 301 detailed incident report. Historically, BLS collected 0 of those, so it's basically a jump from 0 to 1.3 million individual incident reports that OSHA would now receive under this rule.
So what's going to happen? What is OSHA doing? Why do they want this? What are they going to do with this? And this is something we'll talk about at the end, because there may be a dramatic change between what the Obama administration intended to do with this and what the Trump administration will do with this. But right now, the plan is, and the rule lays out, that the data will be submitted electronically through this secure website. OSHA is working on the development of a website, or at least had been through the election, to be a funnel for employers to send this information to the agency. The information can be submitted from headquarters, so you all can collect it at one location at your headquarters and then sift it through this website that OSHA will build one time, or each individual establishment can send it directly from the establishment. OSHA has indicated in their rule that they are going to attempt to scrub employee identifying information. As any of you who work on these logs know, there is information that tells, information that an employee may have privacy concerns about, that tells about their, a past injury similar to this, gives some detail about their medical situation. OSHA is going to allegedly, purportedly scrub the details, especially that you see in the 301 incident reports, from this data before it does anything with it. And I'm going to talk about what they're going to do with it in a second. And as I said a minute ago, this information is going to first be sent. The first obligation you all have is July 2017. That's when you need to have this information in by. And so what is the agency going to do with it? They say that they're going to publish it. The data is going to be published without any context. That is, they're not going to provide explanations that you all might provide as to why your log had this type of injury or illness at your facility. It's going to be generic and blank, and provide to anyone who wants to take a look at this publicly available information what injuries and illnesses occurred at your workplace. The purpose, as explained by Dr. Michaels, is that what the rule is going to do, or is OSHA thought it was intended to do, is to nudge employers to, incent employers to create safer workplaces so that they don't have to report to the public about injuries and illnesses at their facilities. That's essentially the whole point of this part of the rule. The concern about about the rule is there are multiple concerns about the rule. The concerns are exactly what OSHA wants to have happen. What they want to do is use the publication of this data to discourage consumers from doing business with your company if you have a high rate of injuries and illnesses. They want to thwart your opportunities to contract with customers. They want to put pressure on you, essentially, to reduce your injuries and illnesses, have better logs, and make you a more appealing business partner, or make you a more appealing company from which consumers will buy. Additional impacts will be providing, ammunition to competitors. If competitors have better injury and illness picture than you do, they can use that against you, because it's all going to be public. It can be used by entities that potentially want to organize your workforce, or for those of you who are organized, it can be used at the bargaining table when you're renegotiating your collective bargaining arrangements. So, there's a whole host. It can be used by against companies, by banks who would otherwise give you loans. There's a whole host of impacts that OSHA is intending here, and that could be seen if this data is actually made public.
Yeah, what's really interesting about this rule is that we often have a slide like this when we're talking about the potential impacts of a new regulation. Usually that slide has a title something like the unintended consequences, or the consequences that, you know, OSHA doesn't realize are going to happen because they're not, they don't know business, they've never run business. The crazy thing about this rule is that these are the intended consequences. I mean, you look back at what Michael's had to say about this. This is all about impacting the way that investors, job seekers, customers, and the public think about the employers who are going to be covered by this rule. So they intend to harm businesses by using this data that was really never intended by OSHA, never intended by anyone to be a metric of, to be an evaluation or judgment of your safety program.
In fact, you know, the analogy that we make sometimes in the enforcement context is the nasty press release. OSHA under Dr. Michaels has really sort of been genius in a, you know, in a devious way in developing really bad press releases and issuing those when citations are issued that are, you know, meet a certain financial threshold, and the agency uses those intentionally, even though the citation has not yet, you know, sort of been proven. The agency uses those to, you know, create disincentives across similar industries for acting in a way that the agency believes will result in those sort of citations. And to some, you know, really, I think, to some effect. Here, it's even a step, I guess I'd say, worse than that, because there isn't even a citation at issue here. This is just the recording annually of the injuries and illnesses that occur at your workplace. And it's, you know, this rule was promulgated under a clear understanding that the creation of these logs and the recording of this data was not intended to suggest any fault for the employer. This was a way to sort of allow employers to look at their own injuries and illnesses so that they could improve their workplaces, see what's happening, but it doesn't mean that there's fault here. It could be fully an employee's fault. It could be mainly related to what they've done at home, but then there could be sort of an aggravation at work that results in a log entry.
It could be a piece of equipment manufactured by another entity that has a defect or fault, you know, some fault that causes an injury. So this is sort of one last aside, one last little story about this. The idea that OSHA is now planning to use this injury data to harm your reputation when it was never intended that way, in sort of a classic shoot yourself in the foot move by OSHA. On the same day that they published this rule in the Federal Register to become a final rule of OSHA, on that same day they happened to coincidentally issue an interpretation letter regarding a record-keeping issue. An employer had written to OSHA and said, hey, we had an employee who was injured at work, and after the injury, we did a post-incident drug test and confirmed that the employee was drunk at the time of the incident, and we had been able to, through our investigation, determine definitively that his impairment caused by his own drinking resulted in the incident. It is a but-for actual cause of the incident. We assume that we are not required to record that injury on our log, correct? And OSHA replied that no, in fact, it happened while the employee was at work using the instruments of his work, and the fact that he happened to be drunk on his own accord does not eliminate your obligation as the employer to record this work-related injury. So to me, looking at this on the same day, OSHA is saying this data is such an example or such a sign of what kind of safety program you have, we're going to publish it so others can make judgments about you, but you have to record things like your drunk employee crashing a forklift. So it gives you an example of why this is such a misguided direction by the agency.
Okay, so as we said, you know, we'll talk a little bit towards the end about what might happen with this rule, but right now it's in effect, and here are the effective dates that you need to be aware of. For 2016, OSHA has established a sort of a staggered effective date for this rule. So for 2016, for those establishments that fall into this rule because they have 250 or more employees, this year you will only have to submit the 300A, the annual summaries. You will not have to submit the other two types of logs that going forward, you will have to submit. So 300 days only, and that will be July 1st, 2017. That's the date by which you have to submit those forms. That, of course, is the same as those employers who fall into this rule because they are in a high-hazard industry with 20 or more employees. Just the 300 days have to be submitted, same deadline, July 1st. Next year, 2017, the full weight of the rule will kick in unless it's changed by this administration. So establishments with 250 or more employees will have to submit all 3 forms, 300 logs, 300 A's, 301 incident reports, and again, that date will be July 1st, 2018. Same date for those with 20 or more high-hazard industry employers. You have to submit just 300A and by July 1st, 2018. And then from 2018 forward, the date for submission changes to March 1st. So March 1st, 2019, those same documents will be required to be submitted, and that will be the date going forward.
And just to be clear, what you're submitting, the way this rule is intended to work, the reason why it's called the electronic record-keeping rule is that you're not actually sending in, the paper copy of your 300 log or the paper copy of the 300A or the incident reports. It's that you're taking the data that populates those paper forms that you may have at the workplace, and maybe you already have an electronic system, but you're taking that data and submitting it electronically into a database that has, so far as I know, not finished being designed and built yet. So it's about the data submission as opposed to a record submission. They will not, in fact, accept paper records, so this will require either rekeying data into their system or moving to some electronic system that a private vendor designs, develops, and sells, so that you can very easily sort of drag and drop or export the data to more easily submit it to OSHA.
And in fact, this, I just put up a slide here that identifies some of the criticisms that industry has had of this rule during the rulemaking process. Look at the last bullet. I mean, one of the things that we think, and certainly the industry pointed out in the rulemaking, is that the agency has substantially underestimated the time and financial burden associated with compliance with this rule for the very reasons that Eric just described, because this isn't just taking your logs that you generate, making copies and sending them to some address. It's actually creating a new record, if you will, through this electronic system, many new records. So that's one of the concerns. And, we've sort of talked about these other concerns, the idea that these logs were the initial record-keeping rule, 1904, was generated without any sense that these logs would be a sign of employer fault. It was just a good way, and it's a good process that exists right now. It's very helpful to employers generally, but it shouldn't be used, according to industry, to as a critique and as a comparative basis to compare companies across industry. The final sort of main point that stakeholders made in the rulemaking is that OSHA did this new rulemaking, but they really hadn't identified any problem to begin with. Usually you have a rulemaking because, and under the law, you've got to have some basis to do this, and there was nothing that OSHA had identified in the proposed rule or the materials prior to the proposed rule that identified a gap in what existed and why we needed this rule. Yeah,
and then sort of the last other very significant comment that OSHA did receive, really from across the board, from from the labor side, from management side, from academics, is that this rule, without a doubt, if you are going to take employers' injury data and publish it online with the specific purpose of impacting their reputation and their ability to do business, you're without a doubt going to create an environment that will result in underreporting of injuries and under-recording of injuries. Employees do not want their private health information published online, and employers want their records, want their DART rates and recordable rates to be as low as possible if it is going to be out there for public consumption and affect their ability to do business. So everyone's screaming that, hey, publishing this data online is going to result in under-recording and under-reporting. And in response to that, I guess you got a slide on that? Okay.
Yeah. So anyway, just to sort of, and this really leads up to the next part of the discussion, which is the other part of this rule, the anti-retaliation provisions of the rule, which really are very, very significant. And you know, as Eric was just saying, this main concern raised that you're actually creating this incentive for people to sort of make a call, you know, on the instead of making a call that, yeah, let's record this, we're not sure if it's recordable, we're not sure if it's work-related, but we're putting it on the log. And that's helpful to employers to understand what's going on in their workplaces. Now, with this concern that it's going to be used against them, the concern was that they're going to err on the other side and say, you know what, this is a close call, I'm not going to record this. So that was raised as in the rulemaking. Hence, the agency opened to the rulemaking midstream. Everyone thought it was in order to sort of address this problem, that OSHA got it, and lo and behold, they developed this additional supplement to the rule, which is now final, and Eric's going to talk about what that includes.
All right, so that brings us to the anti-retaliation elements of the electronic record-keeping rule, and it seemed like this topic didn't really fit with the electronic record-keeping rule, but it does insofar as it is intended to address the concerns that were raised by essentially everyone that this rule will lead to underrecording and underreporting. So instead of the obvious fix, and I think anybody looking at this says, oh, we can collect the data as an agency to do something productive with it and just not publish it online, because that's why everyone acknowledges that that's the incentive to not record injuries, is because now everyone's going to see it, we want to keep our rates low. Instead of fixing that and saying we just won't publish the data, they instead instituted a new stick, a new form of punishment for creating an environment where underrecording or underreporting is encouraged. So what happened? They added additional elements to the rule, and these are the additional elements. And these things went into effect on December 1st. So just a couple of weeks ago, this became the law of the land, and it is the law of the land as we sit here today. It may change under a Trump administration, but right now, OSHA could walk into your workplace, and if they find a violation of these provisions, issue a citation for it. The rule requires employers to inform their employees, and we'll talk about what that means. Inform is a special word. It's not train. It is inform employees that they have a right to report work-related injuries. And at the same time, what you're really informing them is that they have a right to report work-related injuries free from discrimination or retaliation. And as a second element of this, that's a step you need to take. You need to inform employees of that right. And as a second step, you need to ensure that your internal injury reporting policies, the mechanism by which your employees tell a supervisor that they have suffered a work-related injury, must not have any unreasonable elements. You must not have an unreasonable internal injury reporting policy. That means a policy that may discourage or create an environment that chills employees from reporting injuries or illnesses to their supervisor.
And let me just add one thing right here. I'm sure those of you who are charged with the responsibility to deal with OSHA matters at your workplace all read OSHA's final rules and work to understand them. If you read just the final rule here, as Eric just sort of summarized in this slide, I'm sure most, if not all of you, would say, yeah, we're good. We've done that. We do that. That's not a problem. It's really critical. In this rule, I think probably more than any other rule in recent times, to go behind the rule, to do these sort of webinars, to read the background guidance documents, to read whatever you can and listen. We'll try to give you a summary here in the time remaining, but the language of the rule, you could never intuit from it what is actually required by this rule.
Right.
It's just, there's really a big, there's a disjunction here, and so you have to understand what OSHA means by those seemingly simple words on the page there.
Right, and so we'll spend almost the entire rest of the webinar talking about what is a reasonable reporting policy, but just to real quickly address and move on from the obligation to inform employees of their right to report free from retaliation discrimination. This is not an obligation to conduct a training event. It is an obligation to inform employees, and OSHA has said expressly that you satisfy this requirement if you post at the workplace the most recent OSHA rights poster. So you will have somewhere in your workplace a Department of Labor poster, I think a wage and hour poster, and an OSHA It's the Law poster. There is no requirement under the law to update that posting as OSHA produces a new version of the poster. But if you want to set aside any risk of violating this provision of the standard, all you have to do is go to OSHA's website and print out the most recent version, which I believe is a 2015 version, that uses this exact language. It says you've got a right to report work-related injuries free from discrimination or retaliation. You satisfy the rule automatically if you do that.
You satisfy the first two bullets.
The first
on your,
two bullets,
on the
right?
screen
Exactly.
There.
There are other ways to do this, of course. You could circulate an email. You could post some other notice that covers this issue, or you could address it in a training event. But you automatically address it if you post the newest version of the poster. You get that free from OSHA or print it off their website. So the rest of this discussion we will talk about is this idea of a reasonable internal injury reporting policy. OSHA issued guidance on this in October as to what they mean, as to what the current administration's OSHA means by reasonable reporting policy. And this is exactly as Kate said. You know, there is the word drug testing, the word safety incentive, the word bonus, compensation, things like that do not appear at all in the rule. But if you read the preamble to the rule, if you read speeches that OSHA has given about the rule, or if you read this guidance document that OSHA published, you see that it really is sort of a strained view of, you know, that these things are linked to a reporting policy at all, but the OSHA is viewing all of those elements as part of your reporting policy because they may be the sort of thing that discourages an employee from reporting an injury. So they've attempted to provide some detail about what it means, and they've provided some examples of reasonable and unreasonable reporting policies in the form of drug testing policies and safety incentive programs. So let's take those one at a time. First is the reporting policy itself, the actual mechanism that you provide to employees to tell their supervisor that they've been injured. And OSHA has said through the guidance document and through the preamble that they would consider it to be an unreasonable reporting policy if there were too restrictive and too harsh of a punishment in connection with a late report of an injury. And in particular, if you don't provide for certain circumstances to allow for a later report than you might otherwise like in certain circumstances. And what I mean by that is if you have an injury or illness that has a long latency period, or what begins or appears to an employee to be a very minor injury, he doesn't realize that he has anything that is worth reporting to the employer, but it only develops later into a more serious injury, like a musculoskeletal disorder type of injury where you might feel a little soreness, you might feel a little discomfort, but the next day you realize, now I can't open my hand all the way, or I can't raise my arm above my belly button. Now I realize I've got a serious injury, and this might have been the result of, repetitive stress work over the last several weeks, and reporting it now, several weeks later, OSHA would find discipline for that late report to be a violation of this rule, because you have to give employees some opportunity to recognize that they have an injury that is worth reporting before they report it. Likewise, if an employee is incapacitated or is receiving medical treatment and is not able to report within your reporting window because they're unconscious, in a coma, or in surgery, then OSHA would take issue with a discipline in those circumstances.
And what we're really talking about here is, what does your policy say in terms of the amount of hours, the amount of days an employee has to report? So if you have a policy that says, if you have an injury at work, you have to report it within 24 hours or 36 hours or something like that. That's where you really need to focus in on what we're explaining about what OSHA says is not allowed.
Right, and so they've said, it's okay to say report as soon as practicable. It's okay to say report within 24 hours, but you should build in a caveat that says report as soon as practicable or within 24 hours of when the employee understands or recognizes that they have a reportable injury, and carve out an exception for the employee who is physically unable to report because of the injury itself. So that's the timing restriction. It is okay to have a timing restriction, but it needs to account for some of these circumstances. Another area where OSHA has offered an opinion is that discipline for employees who receive discipline after they report injuries. Now, it is okay, OSHA says, and it would be very disturbing to me if it was not okay, but it is okay to discipline an employee for violating a real and meaningful safety policy. But what OSHA is looking out for is the employees who receive discipline essentially every time they report an injury, and in those circumstances in particular where the discipline is for some generic or what OSHA would consider to be a meaningless rule. For example, the employee reports a serious injury or a cut to their hand, and you discipline them for not working safely, or you discipline them for not maintaining situational awareness. OSHA would accept a discipline, it seems to me, in connection with not following the company's lockout-tagout policy or removing a guard from a machine, but a generic, you didn't work safely, therefore you're disciplined, OSHA would take issue with, because there they would see the discipline is essentially a discipline for reporting an injury, not for violating a work rule. And that's at the heart of this. OSHA wants to make sure that you are not thinking, that you are not implementing rules that are intended just to be a form of discipline for getting hurt. Because when employees realize every time someone reports an injury, they get disciplined, maybe they're going to get hurt at work and say, gosh, I can't afford to get disciplined, or this is my second time, so I'm just not going to tell my supervisor that I got hurt. That's the basis for this rule here. The next big elements, and these are the things that we've gotten the most questions about, the things that industry is most concerned about, is drug testing and in safety incentive programs. So in the context of drug testing, OSHA has said employers should not implement a drug testing policy that has the potential to dissuade a reasonable employee from reporting a work-related injury because of an invasion of privacy. And they provided some detail around what they're actually looking for and trying to prohibit. And what OSHA is trying to prohibit here is the use by employers of a post-injury drug testing policy to serve as a form of discipline. If you get hurt at work and you tell us about it, we're going to drug test you, and that is essentially a form of discipline, because you might your job may be in jeopardy for totally unrelated drug use, but know that if you report, you're going to be tested. So to the specifics, to the guidance that OSHA has offered, they are prohibiting blanket post-injury drug testing policies. If you have a rule that no matter what, any employee that reports an injury to you will be drug tested, that is the type of policy that they consider to be a violation of this standard. This does not eliminate all drug testing, so you're still permitted to conduct pre-employment drug testing, as much random drug testing as you'd like to do, any drug testing that is required by state or other federal laws. For example, the Department of Transportation does have mandatory post-vehicle accident drug testing, and so if you have a policy that complies with DOT, that for automobile or transportation-related incidents, there will always be a drug test, doing that would not run afoul of this new record-keeping rule. You're also authorized under this rule to do any form of drug testing that may be required by your state workers' compensation law or required by your private workers' compensation insurer. And that includes, in the guidance, it makes this clear, something that may not be a legal requirement by the workers' compensation entity, but if you have enrolled in a voluntary premium reduction policy, and as one of the elements of that premium reduction policy calls for automatic post-accident drug testing, you can comply with that provision of your workers' comp agreement. And I know employers who have not participated in that historically and who are participating in it now so that they can continue their drug testing program. And then finally, it's not that all post-accident drug testing is prohibited by this rule either. There is post-accident drug testing can be conducted when it is likely that drugs or alcohol contributed to the incident and that the test itself can identify present impairment. So let's dig down a little bit deeper into what that means. OSHA is essentially saying post-accident drug testing can be done when it is a tool as part of your root cause analysis. If you are really trying to identify the cause of an accident and you are doing drug testing to advance that analysis of cause, that is fine. It only prohibits drug testing where there is no reasonable basis to believe that drugs or alcohol could have been a cause of the incident. So this is a little bit less than sort of the probable cause in the criminal warrant setting. It is essentially that the accident is the type of accident. You know, what I'm saying is you don't need to see the employee stumbling around after the accident and slurring his words. It just has to be the type of incident where that employee's state of impairment could have been a factor. You know, operating a forklift where motor skills and sort of cognitive recognition are the sort of things that, you know, are important or are factors that could have led to an incident, then you can do drug testing.
But for instance, think about an MSD and, you know, a trigger finger or some repetitive injury. There's likely not a correlation between alcohol abuse or drug use and, you know, a repetitive MSD type injury. So if you do testing after that sort of injury is reported, it would be seen as a pretext and a form of discipline to this worker just because they got injured and they, you know, kind of you've got a log entry there.
Right, and so there are these 4 factors that OSHA is looking for when they evaluate how you implement your drug testing policy. It's, is there some basis to believe drugs or alcohol contributed? Are other employees treated similarly? So if you've got, and they give an example, and I'll just talk about it right now and then skip the slide where I talk about it, is you've got an incident involving a crane operation where you have a rigger who attaches the load to the crane, you have a flag person who is, you know, guiding the person operating the crane, you know, when to move, how to move, what direction, what speed, and then you have the crane operator, and an incident occurs where the load is dropped and it injures a 4th employee who happens to be working nearby but who has nothing at all to do with this crane operation itself. If you test only the employee who was injured in that crane incident, where their state of mind, their, you know, impairment could not have been a cause of the incident, and you don't test the crane operator and you don't test the flagman and you don't test the rigger, OSHA is going to look at that and say this drug testing is purely a form of discipline for the person reporting the injury and not really about identifying the cause of the accident.
Which of course then has a effect of having people not report injuries because they're going to get drug tested. So that's sort of the point.
Right. And so the another area where OSHA is a little bit more relaxed in post-incident drug testing is if it is work that is being done in a role or by an individual in a very high hazard task, or a person whose role is you know, critical to the safety of the workplace, that you might have a heightened interest in identifying drug or alcohol use because that person is engaged in a high hazard task. And then finally, there was this element in the original guidance in the preamble to the rule where OSHA says the drug test that you employ must be one that can identify present impairment. And everybody sort of went crazy about that and said, well, that makes sense from an alcohol standpoint, but there is no test that says this person smoked marijuana within the last hour. It is just something that tells you whether it is in the blood, and that's true of essentially every narcotic test that is available. And so OSHA backtracked on that in the guidance that said the ability to identify present impairment is only an issue for alcohol testing, not drug testing. So this is the example that I've already talked about with the crane operator. So I'll move on real quickly to the safety incentive element here so we've got time for questions. OSHA is concerned about the potential chilling effect and retaliatory nature of certain types of safety incentive programs. And what this boils down to is that OSHA believes that if you incentivize by monetary reward or any type of reward or benefit, or punish for the opposite, the absence of injury, you create an incentive for employees to not report their injuries. So if you give a prize, whether it's a pizza party or gift cards or the participation in a safety bingo to a crew of employees or to individual workers because of the absence of injury, because they went 6 months without a recordable injury, or they went a year without a recordable injury, or they reduced the recordable injury rate or the DART rate at that workplace over the course of the year, you are rewarding the absence of injury. OSHA believes that those types of rewards create an incentive for employees to just keep their mouths shut about an injury. I'll deal with this on my own so that I get to have a pizza party. To me, I think that is an insult to employees. I don't think that there is evidence that bears it out. There are people that do. OSHA, the current administration, is among that group. So they have come out and said that those types of safety incentive programs that are linked to injury rates or linked to the absence of injury are unlawful under this rule. So that's pizza party, safety bingo, gift cards for employees or a crew who have no injuries. It's rewards or denies of benefits or bonuses based on an injury rate, things like that. It includes also compensation, bonus structure or compensation to low-level managers, frontline supervisors, and employees, direct employees, tied to injury rates. The further you get away from the front line, the more OSHA would find those types of bonuses and compensation schemes acceptable. So what they've said is things like a plant manager's bonus or a site safety manager's bonus cannot be tied in any way to injury rate or the absence of injury. But if you get to a regional operations manager or a corporate safety director, those can be factors in their compensation. And the idea being the closer you are to the individual employees and you have a benefit tied to the absence of injury, the easier it is for you to create an environment that chills the reporting of injuries. Now, OSHA has gone and said, we're only talking about those types of negative safety incentive programs. We are perfectly happy with positive safety incentive programs, those types of incentives that reward leading indicators rather than lagging indicators. And there's some examples here with the Facebook thumbs up here. OSHA likes raffles and incentives and bonuses and rewards that reward all employees for complying with a legitimate safety rule. So for example, if you do weekly or monthly safety audits and you've completed a month of audit where everyone at that workplace was in compliance with the PPE policy, then you can reward that with a pizza party or safety bingo or gift cards or something like that. You can reward a group of employees if everyone in that group completes their mandatory training by the deadline that's set for that training. You can reward individuals' participation in a proactive safety function, like participating in a safety committee or identifying and reporting an unsafe condition. You just cannot reward the absence of injury. So just real quickly to give you the landscape and the lay of the land of where this rule is, a number of industry groups participated in a legal challenge to this rule. That challenge is ongoing.
And by the way, the legal challenge is to the anti-retaliation portion of the rule that Eric just talked about, not the electronic reporting portion of the rule.
Right. And so as part of that lawsuit, the industry stakeholders are basically saying this rule is unlawful. It was OSHA did not follow the Administrative Procedure Act and do all the things they were required to do in terms of a proper cost-benefit analysis for the rule, because there was great bias in the idea that safety would be improved by eliminating post-injury drug testing and safety incentive programs. And in fact, there's a lot of evidence out there that safety will be harmed by restricting drug testing and safety incentive programs. And so this legal challenge was made. As part of the challenge, the industry groups moved for a preliminary injunction that would have barred OSHA from enforcing the rule until the overall challenge was decided. That preliminary injunction was just denied within the last 3 weeks. And so that December 1st date became the effective date, and so the rule is in effect. The legal challenge continues, but it may not be decided for several more weeks. And in the interim, OSHA can enforce the rule as it is written. So real quickly, we'll cover some things we think you ought to do now, and then we'll open it up to some questions. In connection with the first part of the rule, the electronic data submission rule, we think it is a very, very good idea to provide refresher training to your record keepers in the requirements of the record-keeping rule. Now that OSHA is going to get your injury and illness records, that opens the door to a lot easier enforcement. So you've got to be careful to not under-record or to not record incorrectly, because OSHA is going to look at this and perhaps use it against you in the enforcement context. Conversely, you don't want to over-record because your data is going to be potentially going to be available to the public. So it is critical, I think, to have a very solid understanding of what's recordable and why, and to make sure that your records are perfectly accurate. So train the people who are doing the record keeping, and as a second step, start implementing, I think, at least an annual audit of your injury and illness record keeping forms. And I would do that basically starting January 1st of the next year, as quickly as you can. Have a very comprehensive audit done before the 300A is due to be completed and before the data is to be submitted to OSHA. You should also evaluate and update your injury and illness reporting policies to ensure that they do not run afoul of the anti-retaliation elements that we talked about today, including take a look at your drug test policy and make sure you know, if you have post-incident, mandatory post-incident drug testing, that you fit in one of the umbrellas that allow you to continue to do that. And if not, I think back away from that policy and implement something that is more consistent with the guidance that OSHA talked about, and similarly with the safety incentive programs. If you are an entity that is a big proponent of drug testing and feel like this would be too much of a restriction on the post-injury drug testing, look into whether there's a workers' comp policy that you might adjust to be able to allow to do it mandatory, and if not, consider increasing the amount of random drug testing that you do. I would definitely recommend posting the latest version of the OSHA rights poster so that there can be no question you've satisfied that element of the rule. And then, for heaven's sakes, whatever you do, hide those pizza boxes when OSHA shows up. There's nothing more egregious than daring to provide pizza to your employees for keeping themselves safe. So. And
let us just end by saying that, you know, we just spent an hour basically talking to you about this. We do not know whether the Trump administration is going to actually make this rule as robust as the Obama administration wanted it. That there are certain things that they could do pretty easily. For instance, on the electronic record keeping, they may not get this special portal created. You know, they just may let that process lag and sit around, so there might not be a portal created to send that data. If they do get it created, they may take the data, you have your deadlines to comply with, but they might not do anything with it. In fact, if I were betting, I would bet on the fact that this administration is not going to publicize that data at all.
Right, that they'll finish the database, they'll have employers who are covered by the rules submit the data, but they'll use either an internal budgeting mechanism or even a rider in a appropriations bill in Congress to say that OSHA shall not spend a penny doing anything with the data online, publishing the data, anything like that. Well, so it would be a way to effectively kill at least the publishing of the data side of this.
And the administrator may not, you know, the administrator may say, we're not going to publish this.
Right.
And then on the anti-retaliation provisions, we think similarly, this administration, you know, they're on the books, but the language, as we pointed out, is very broad, very vague, very general. They may say to the head of enforcement, you know, don't worry a lot about that stuff. Focus on something else.
Right, and one thing we did learn over the last 2 years was the Supreme Court decided a case called Perez v. Mortgage Bankers that said that agencies can significantly change the substantive meaning of a rule by way of an interpretation letter without going through rulemaking. And that's essentially what OSHA has done here, is they wrote a nothing rule that says you must be reasonable, and then used an interpretation letter, that guidance memo that I talked about, to build in all of this meaning around drug tests and safety incentive programs. the new, OSHA under a Trump administration could easily archive that memo and issue a new memo that says what this rule means by reasonable reporting policies is that, you must allow a reasonable amount of time to report, and you must, have a reasonable mechanism to explain to employees the people to whom they should report their injuries, and that this rule has nothing to do with drug testing or safety incentive programs. And that is what I would expect is likely to happen here, regardless of what happens to the legal challenge, regardless of all the potential machinations with Congress, the Congressional Review Act, another rulemaking. All those things are really hard, but what's easy is writing an interpretation letter that says, forget what those guys that just left the keys for us, forget what they said, we're going to do it this way. And I expect that's probably going to happen. Unfortunately, the rule is in effect today. It is very unlikely that OSHA is a high priority for the Trump administration, for any administration, as important as it is to my life and to all of you who thought this webinar was worthwhile, as important as it is to your lives. OSHA is not the first thing that a new administration addresses when they come into power. So I think it is possible that we're going to not see a new OSHA administrator until the fall. In which case the folks who are career people at OSHA, not the political appointees, the career people who all tend to lean left and be enforcement focused and who love this rule, are going to have the opportunity to enforce it for up to a year before someone steps in and says, hey, let's go a different direction with this. So it puts employers in a tough spot as to what to do here, but it is the law of the land as we speak. One last thing before we go to questions. You see up on the slide here, we have a blog, a terrific blog called the OSHA Defense Report that is chock full of really great information about this rule and other breaking OSHA events and rules and activities that you need to know about. I would encourage you to check it out, the OSHA Defense Report, OSHADefenseReport.com. I'd love to know that someone other than my mother is reading it, so please get over there and check that out. And with that, let's open it up to some questions.
All right, thank you very much, Eric and Kate. We have had a few questions come in, but your presentation has done a really good job of answering those, so we just have a couple outstanding questions I'd like to have you address. The first one is, if our primary facility has 25 persons within the walls, but 10 of those people are considered to be corporate employees and 15 are assigned to the distribution location, how do we handle that? Does that location fall into the 300A requirement?
So that's a terrific question, and I want to make sure there's two potential components there. One is, and we did in the slide talk about corporate entity at that location. If they are two different corporate entities that you're talking about, the parent company has 10 employees there and a separate incorporated entity that respects the corporate form and has its own board and its own management and its own books, its own financial books, you would do a separate count for those two companies. If we're talking about a single company, but you've got entities from corporate who are present, the analysis goes this way. I look at it, when you fill out your 300A at the beginning of the next year, you have to count employee hours worked at that location. And so what you're doing when you figure out that employee count at that location, you are looking at all of the employees who perform work at that location, who you supervise on a day-to-day basis, and who are tied to that log. If they were injured, their injury would go on that log. So all of the employees whose injury would go on the log for that establishment and whose hours count towards the 300A for that establishment count towards this employee count. So if you have a mobile employee, he's from corporate and he travels around to 10 different locations throughout the year, but if he is injured, his injury would report back to the log at corporate, and his hours for that year are counted on the 300A for the corporate log, then you would not count that employee on that establishment's log. So I hope that addresses your question. If not, definitely feel free to reach out to us after or type in a little bit more nuance to the question and we'll try and address it.
Thank you, Eric. We have another question from somebody, I believe, who may have come into the webinar a few minutes after it started. looking to get a little more clarification on branch locations that may have less than 20 employees. They just want to make sure that they're clear on the differences in report requirements.
Yeah, and so I would say the analysis is essentially the same as to what I just reported. And to me, the way I view this, instead of thinking about the four walls of an establishment, I think about a 300 log, because there are interesting business arrangements out there where you might have even construction, for example, where you might have crews of 4 or 5 people who are working just sort of at different locations every day and different locations than the rest of their team. But if that crew reports back to some central location where you have a 300 log that covers all of those workers, then that log is essentially the establishment. So I think about every location where you have a unique 300 log, what are the employees whose injuries would go onto that log? And incidentally, there is some discretion that employers have in how to manage those unusual work situations. If you have a handful of small locations in a general area, you can roll them on to one log. Under this rule, it might be advisable to not do that. You might have 100 more 300 logs than you had in previous years, but if that means you've got 100 workplaces with 10 employees instead of 10 workplaces with I'm not a mathematician, but more than 20 employees, that might be a reason to keep separate 300 logs for smaller discrete locations to avoid having to report data into OSHA. But the general concept is you have to keep a 300 log for each establishment. So whatever way that you have devised to comply with the record-keeping standard to tie your 300 logs to different employees, that's the way this rule is intended to apply also.
And just to be clear, if it's a simple case, if you fall into the high hazard category, but you have less than 20 employees, the answer is simple. No, you do not have to, this rule does not apply to you.
Right, not corporate-wide. And it may change from year to year, right? You might have 22 employees at peak employment in 2016, so you report your 2016 data in July 2017, but during 2017, you end up with only 18 workers at peak employment at that location. You don't have to report that location's data the following year.
Okay, we have one last question here before we wrap. The question is, should we prepare and post the paper version of the Summary 300A for 2016 or wait for the electronic site to be available?
Yeah, so great question. This rule does not change the obligation to prepare 300A and post it for employees at the workplace the same way that it's always been. This is a new and additional requirement. So to the extent that you were doing that in the past, as you're required to do, you will continue to do that for, until they change that rule. So the idea of submitting the data electronically does not affect that obligation at all.
So post that where you always post it.
Okay, that is all the questions that I have here in the queue. I want to thank you, Eric and Kate, for being a part of this webinar. Very insightful. And thank you to all of our attendees today. In the near future, you will receive an email directing you to a replay of the webinar and the associated documents. Also watch your email for announcements about future webinars, and be sure to visit the ASA website at www.asa.net. We appreciate your participation today, and have a safe day.